Well, good morning, everyone. I'm Judge Boonstra, and on behalf of my colleagues, Judge Young and Judge Karobkin, welcome to the Michigan Court of Appeals. We are looking forward to your arguments. Before we begin, let me just remind you, as we always do, especially for those who aren't here regularly, that we have been studying your cases for some time. We know them quite well. I think you'll find as we go forward that we understand the facts of your cases very well and the legal issues that are presented. And for that reason, we ask that you bear that in mind as you present your arguments, and you can really just come up and hone in on what you believe to be the most compelling arguments on your side and why you believe you should prevail in the case. If you have a case involving minors or victims of crimes, please be sure to use their initials rather than their full names. These proceedings will be broadcast on YouTube, and we want to make sure to protect their privacy interests. So with that, let's jump right into item number 14 on our docket today. This being the second day of our call. We had the first 13 yesterday. Item 14 is case number 376546, People versus Timothy Edward Headley. I believe we have one attorney here in person and one appearing remotely. Good morning.
Good morning. If it pleases the court, my name is Zachary Sylvain. I'm the assistant prosecutor for Mackinac County. This case deals with a number of issues, particularly with regards to proper standard review when motions for new trials being brought forth, along with judicial prejudice. Now, in this case, the lower court utilized an incomplete standard review, which they stated in their order and opinion that when it comes to the motions for new trial, that considering all the evidence in light most favorable to the prosecution, no rational trier of fact could find that the essential elements of the crime charge were proven beyond a reasonable doubt. The court was relying on People v. Mehall 454 Mich 1. The missing portion of that is contained in People v. Cairns 460 Mich 750, which ends with circumstantial evidence and reasonable inferences arising from that evidence can constitute satisfactory proof of the element of the crime. And in this case, the issue was whether or not there was sufficient evidence that fellatio had occurred. The defense obviously took the position that there wasn't, particularly when it came to the issue of entry. Our position was that there was, based off of the record and the testimony from the victim, which, when going into the lower court's opinion and order again, with regards to the issue of fellatio, the court stated a CSE conviction under the theory of fellatio as defined by the Michigan Supreme Court requires a showing of entry of the penis into another person's mouth. The testimony of the victim, CC, touched her lips with his penis and moved her lips. There was not any testimony or other evidence to show that the defense penis entered her mouth. Hence, a fellatio theory cannot be sustained. Now, the testimony was not quoted or cited to in that order and opinion. In our answer, we did provide very specific points within the record, trying to draw attention to it for the court. One of the things that really stands out is on the first day jury trial transcript, on page 164 through 165. Question. Okay, all right. Did he ever actually succeed in getting his fingers into your vagina? Answer. What do you mean by that? Are you talking like four? And then the prosecutor cut in. Okay, on human anatomy, the vagina has a lip area. And then he proceeds to go through that and confirm. Now, when it comes to looking at whether or not to grant a motion for new trial, it's to be done on the entire record and not just a portion of it. When looking over the order and opinion, it would appear that the court stuck with more of a, I call it a magic word analysis, looking for either enter, entry, penetration, things like that. But that's not required. And uh, that goes towards the 13th juror issue, where it shows that the lower court judge gave zero weight to that evidence, particularly whether or not it's something that could have provided reasonable inference for the jurors. Also, with regards to the 13th juror standard, in People v. Lemon 456 Mich 625, starts off with the 13th juror standard posits that the authority of the trial judge is equal to or greater than that of jurors when the court does not agree with the outcome. That is important in this case for two reasons. First, as Ori mentioned, the lower court already gave zero weight to any other evidence, particularly evidence that could be that the jurors could draw inference from. However, there's an additional one, and that is that the lower court judge was already in disagreement with the outcome. Messages that were obtained through a separate investigation revealed that Judge Rahali had been in communication with a former Judge Graham for a number of matters, but they showed ultimately that he was in fact prejudiced against the Mackinac County prosecutor. In this case was specifically being mentioned during the trial itself. When it comes to the disagreement, Judge Rahali wrote to former Judge Graham, "The jury is deliberating, I suspect not guilty." Judge Graham inquired about matters, and Rahali followed up with, "More than one victim, testimony was hard to follow. The direct examination was bad." And ultimately, I guess we have a verdict, wow, guilty on all counts, CSE 1, which Judge Graham responded with, "Damn, I guess they believe the girls. That's good." Now,
Mr. Sylvain, I have a question for you.
yes,
So when I read the trial court's holding about why it granted a new trial, it seemed that there were two grounds. So one is one that you've talked pretty extensively about, which is sufficiency of the evidence, but the other was based on ineffective assistance of counsel. When I read your pleading in this court, you have two issues. One is arguing that there is sufficient evidence. The second is arguing that, as you are now, that the judge was biased, but you don't appeal the ineffective assistance of counsel holding. So even if we were to agree with you about the sufficiency, there is a separate reason for granting a new trial, which you have not appealed to this court.
I believe they are interconnected, Your Honor. If I recall correctly, the ineffective assistance of counsel was based off of the defense attorney failing to make a specific request for jury instruction, which was based off of whether or not the evidence was sufficient, specifically a unanimous or unanimity instruction.
Specific unanimity as between the two types of CSC that were charged here or alleged here.
Correct.
And
So if
you
there's
think that's sufficient to call that issue into question as well?
I believe that if there's sufficient evidence to establish that fellatio had occurred, then the specific unanimity instruction is unnecessary and becomes effectively moot.
Oh, that's interesting. Can you explain that a little bit more? I was sort of under the impression that they're two independent.
Well, if I understand how this was being handled by the lower court, the motion ultimately dealt with whether or not there was sufficient evidence to establish a fellatio theory, whether or not there was, in fact, evidence of entry into the mouth. That was the primary argument that was being put forth, and that due to their, on the defense side, claiming that there was not sufficient evidence to establish the entry, that by failing to request a specific unanimity instruction, that would also be ineffective assistance to counsel.
But let's say there was sufficient evidence for the fellatio theory. Doesn't the jury still have to be instructed that they have to be unanimous regarding which theory they've decided that the defendant is guilty on?
It's my understanding that a general unanimity would be necessary under that circumstance when there's sufficient evidence to support each theory.
Well, it's my understanding that the trial court held otherwise, and if that's correct, it seems to me it would be incumbent upon you to challenge that on your appeal, which I don't believe you've done.
Well, I guess that is something that I should have addressed further then.
All right. Anything else?
Just that with regards to the appellee's reliance upon case law requiring the unanimity instruction, People v. Urbanski, that dealt with an OWI case with two alternative theories, being either the defendant was guilty of OWI on the basis of being under the influence or under U-ball, unlawful blood alcohol. However, the evidence in that case was specifically showed that the blood alcohol was a 0.064, which could never show that was a U-ball. Similarly, with the People v. Johnson case, that evidence dealt with that there was only a touch or kiss. There was never any supportive evidence regarding penetration. Thank you.
Actually, I just have one thing. If this case does go back for retrial, isn't Judge Rahilly off the case at this point?
At this point, yes.
Yes. Okay. All right.
All right. Thank you, Mr. Sylvain. You do have time for rebuttal, but let's hear from the other side.
Good morning, Your Honors. May it please the court. Tim Doman on behalf of Tim Headley. So with the sufficiency of the evidence issue, I think that's pretty straightforward. The case law requires entry into the mouth. That's not what the complainant testified to, and I don't think that can be fairly inferred from her testimony. The prosecution's argument seems to be that this particular complainant was using touch and penetration synonymously, but she also referred to touches on her breast, touches on her legs. So these were not, she was not using these terms interchangeably. I did want to mention, I don't know if the court, it was brought to the court's attention, but in the reply brief, the prosecutor is asking this court to kind of wholesale reconsider the definition of fellatio under the case law. Not something that was raised below in the application in the brief on appeal. Case law says you can't raise a new issue in the reply brief. So I think the court should disregard that one. I'm glad the court mentioned the issue about specific unanimity based on the court's questions. I think it understands that that's a separate issue, that even if we lose on sufficiency, we still have that as a separate basis for the new trial grant that was not appealed by the prosecutor. So however this court feels about sufficiency of the evidence, I think we still get a new trial on that ground. For judicial prejudice, I know that's kind of the eye-catching part of this case. I don't think the court needs to get into the merits of it for a few different reasons. Obviously, if this court says I get a new trial based on specific unanimity, then, it goes back and the judicial disqualification issue plays out separately. But even setting that aside, and please stop me if the court doesn't want to hear this, but first of all, I think there's a waiver issue here. I don't see how this is not harboring an appellate parachute when you know of the grounds for disqualification and intentionally choose not to raise them for a tactical reason. And I understand that they are saying that, well, we didn't want to compromise the separate investigation. I take at face value that that was the reason why they did what they did, but I still have not heard any elaboration on what was this separate investigation and why would a disqualification motion of this other judge have compromised this other investigation. So I don't think any of that takes it outside the realm of waiver. And as I wrote in my brief, litigants often have good reasons why they waive certain issues. That doesn't make it any less of a waiver. Doesn't mean you get to resurrect it on appeal.
Well, and to Judge Koropkin's earlier point, the judge in question is no longer on this case, isn't that right?
Correct. And so that was my next point, is that we are also appealing the disqualification decision by Judge Burmeister. So that's still a live issue. And so it would not be proper at this juncture, I would say, the new trial should be reversed because Judge Rahali was biased when the issue of bias is still being litigated.
That's a separate appeal.
Correct. That's
Got
a
it.
separate
Okay.
appeal. And so there's also, I raised the issue of taint purge, that this court is basically reviewing the sufficiency of the evidence de novo without deference. So even if there was any bias, then it's going to be washed out by this court's de novo review of the sufficiency issue. And so at the end of the day, I think to me, this court should hold that there was sufficient evidence to support, or insufficient evidence of the fellatio theory, and to hold that the issue, if need be, setting aside the specific unanimity, that the issue of judicial bias or prejudice was waived. I think that's the cleanest way and the correct way to go about this. So if there are any other questions, I'm happy to answer them.
I don't.
Thank you, Mr.
All right, thank you very much.
Any rebuttal, Mr. Sylvain?
No, Your Honor.
All right. Well, thank you both for appearing today, and that case will be submitted. Moving on to item number 15, case number 376370, People versus Matthew Ryan Rademacher. We have one endorsed party, Mr. Stanley.
Good morning, Your Honors.
Good morning.
May it please this honorable court, Attorney Frank Stanley appearing on behalf of appellant. I noted last night, and kind of looking through the pleadings, that I referred myself as the appellee, so I apologize. Your Honor, this appeal is taken on the trial court's denial of the defendant's motion to admit the testimony of two expert witnesses pursuant to MRE 804. I know the court to be well prepared, and I certainly want to respect that, but there are a few bullet points I'd like to discuss that I think hopefully put this in focus. The defendant was charged with first-degree child abuse and first-degree murder. I was not the trial counsel. There was a jury trial. The defendant was the caregiver for the child on the morning of the child's death. There were no witnesses to the cause of death, and there was no lay witnesses to the defendant's culpability. Significant issue at trial, and the prosecutor recognized it. The prosecutor relied heavily, therefore, on the testimony of the medical examiner, Dr. Stephen Cole. Dr. Cole attributed the child's death to blunt force trauma and classified the child's death as a homicide. Prior counsel had no expert to rebut that witnesses. The defendant was convicted. And at that point, I took over the file, and a timely appeal was made. After review of the facts and the transcript of the motion for a new trial to request a Ginther hearing was requested and granted. The motion for a new trial was filed on June the 2nd of 22, and the first day of the Ginther hearing took place on two different dates. On the first date, December the 1st of 22, Dr. Werner Spitz testified, and on the second date in March of 23, Dr. Diaz testified on behalf of the defense. The defense, in a motion for a new trial, has an obligation, as it has the burden, to demonstrate that the trial counsel's performance was deficient and that counsel's deficiency performance prejudiced the defense. People versus Taylor. Prejudice is shown if reasonably probable that the court's error, the counsel's error, forgive me, the result of the proceedings would have been different. People versus Jordan.
Mr. Stanley, can I interrupt? I just want to kind of narrow in on the issue that's of particular interest to me. So there's two experts, both which provide testimony that's unquestionably helpful to your client. And I don't mean to undermine it. It's by saying helpful, it's very clearly critical evidence. One expert's died, one expert is in the same job, but has limitations on the type of hearing they can testify in. Is that?
That is correct. Your
Okay.
Honor.
So even if we accept, well, we have to, the one guy's dead, but if we accept both are unavailable under the court rules, my concern is, that I don't disagree with the trial court that, the prosecutor didn't get the same opportunity for cross-examination. Specifically, it was either defense counsel or the prosecutor tried to get these experts to opine about the injury that caused the death, and the prosecutor objected and said, this is really about, did you contact an expert? What does consultation with experts look like? It's not about the cause of the death, whereas trial, I think, would be. And so I don't think there's a general rule that says you can't use Ginther testimony when the expert's unavailable. But I think here, the way the expert testified at the Ginther was just so different than trial that there's not a match there. So how do you argue that conclusion by the trial court? Because I'm having difficulty seeing any error in that.
Sure. Thank you, Your Honor. Let me
Yeah.
try to focus on, there's about three parts of the answer to that.
Okay.
The first question is, the prosecution chose to make an objection on the first day of the hearing, December 1st, to Dr. Diaz. And I state on page, I can give the page number to the court, but I'm trying to meet my burden under Ackley. It's not enough just to prove that there's experts that are available. I believe, and I put the authority of several cases on this point following Freckenberg and Ackley, that I have an obligation to demonstrate not only that witnesses are available, but how they would testify inconsistent with what the government, in this specific case at least, what the medical examiner testified to. The prosecution at the December 1st hearing objected to that, and the court sustained the objection and limited me on Dr. Diaz. I think it's significant to note, I strongly disagree with the appellee's position in their brief that objections were made. They were made as to Dr. Diaz, but on January 4th, a month later, slightly more than a month later, I disclosed Dr. Diaz. He is the head medical examiner from the District of Columbia. The government had almost 3 months of notice to prepare for that examination, and they did not object. That's not pointed out in the appellee's brief. It is pointed out in mine, and I want to emphasize that. They did not object. And in fact, they cross-examined him for 20 pages because I think they figured out by that point that I have a very meritorious reason to want to develop that testimony. To meet my burden, I have to demonstrate to the court that testimony was available that if presented to the trier of fact would have given them reason to doubt Dr. Cole. Is that responsive to the first question?
Yes, but if you'll indulge me, I just want to make sure I understand it. So it sounds like so it's incorrect that there was an objection to Dr. Spitz.
There was.
There was an objection to Dr.
There
Spitz.
was.
There was not an objection to Dr. Diaz.
There was not.
Okay. So there was an objection and a cabining of the testimony for Dr. Spitz.
Yes.
With respect, and Dr. Spitz is the one who has since passed.
Yes.
Okay. So your response to the trial court saying you didn't engage with Dr. Spitz in the same way you would have at trial is, yes, that's because of you. And your objection, that's not because that's the way the Ginther should have gone. That's not because that's the way I wanted it. That's your own doing and your own wishes granted. And so kind of you're stuck.
The court is correct.
Okay,
Your Honor is correct. They are using it as a sword and a shield.
got it.
We objected. The judge agreed. I think that is an error of law. It's an error of law because I have a duty to present that evidence. We also directed the court. What happened is Dr. Werner Schmitz, what's critical to understand in this case is Dr. Stephen Cole is the medical examiner from the government, one of the most well-recognized and established and candidly credible medical examiners in the state. He's used by numerous counties. I have used him on cases before. So if I'm attacking Dr. Cole's opinion, not only do I have a legal burden to establish that the court, but I need to do it as credible as evidence as possible. Dr. Werner Spitz was actually practiced for over 60 years. He testified in front of Congress on the Kennedy assassination. He has done tens of thousands of medical exams. And if the court recalls Ackley, he's actually named in the Ackley decision. He is that credible. So that's my first expert. But what happened during the testimony, and at that point, he's the only one I had signed on to assist the defense. He's aged. He had trouble with his hearing. He wasn't being totally responsive to my questions. Ability as a medical examiner to testify in these matters. And it took me months to get him to review the material. But when he reviewed it, he agreed with Dr. Spitz and agreed to assist me. At that point, he testifies. The only issue was, could he do it by Zoom? Because he's in the District of Columbia. We filed a motion. The judge agreed. We did it by Zoom. And he testified. And he was cross-examined by the prosecutor for 20 pages. And there was no objection to his testifying. So they had the opportunity. I don't think it can be said with a straight face by the government that they did not have an opportunity or desire to cross-examine him. They obtained a verdict. The issue in this case is the verdict going to be set aside because it wasn't a proper trial. So I think as of March, I can't speak for the prosecutor, but it's clearly a different tactical position. They make no objection and they choose to cross-examine him. And at that point, I have no idea that he won't testify. When the new trial is granted, I put him on notice. We're going to get a trial date. Can you assist me? And that's when I learned the District of Columbia will not allow him to testify at a trial. And I attached his affidavit to my pleadings. He will assist. We were trying to set up an appointment between Dr. Diaz and
Mr. Stanley, let me just, I want to just clear up one thing about the difference between the Diaz and Spitz testimony. Was there anything on the record to reflect change? Like, did the trial judge ever say between the two testimonies, oh yeah, let's like forget what I said about Dr. Spitz, you can go all out on Dr. Diaz? Or was it just kind of no one objected and it kind of just went on? I'm not articulating this very clearly, but you seem to be saying something happened between the court and the prosecutor treated Spitz and Diaz differently. And I'm wondering if there's anything in the record to like show that.
The direct answer to that question is no, Your Honor, not that I can recall. What I think is significant, however, is this is why I think the trial court made an error as a matter of law. Because in his ruling to deny my 804 motion, he says, the trial court says, puts it in their brief, it cannot be said that the prosecutor had the same opportunity given the restrictions I placed on him.
And you're saying, yeah, but you only placed those restrictions on Spitz, not on Diaz.
Correct.
Okay, so with Diaz then, so we know why Dr. Spitz is unavailable, and there's a specific section of the court rule that says if the person is deceased, they're unavailable. That's kind of easy. Which subparagraph of Rule 804A makes Dr. Diaz unavailable? Because the trial judge says it's premature, and this is a motion in limine, right? So we're not at trial yet. He said it was premature to decide that Dr. Diaz is unavailable.
The premature issue is a separate issue, but I hope I'm addressing the court's concern here. The case law interpreting that, and the government and the appellee in their brief agrees, Farkuse, I'm sure I'm pronouncing it incorrectly, but makes it clear. This is not a exhaustive list of the reasons it's unavailable. Under Meredith, the court said it's a non-exhaustive list, and there are other reasons. We use a common sense approach to what that definition means. Unavailable. It's not the reason he becomes unavailable. And let me point out, I'm sorry, I'm just so dry mouth here. It's not the reason a witness is unavailable. The prosecution makes much of the fact that this is a motion for a new trial and not a preliminary examination. It's usually the government that's filing an 804 motion because for lots of reasons, witnesses become unavailable. Assertion of the fifth, they can't be found. And the government is frequently filing 804 motions. And at a preliminary examination, it cannot be said with a straight face that the government has as much of motivation, or the defense does for that matter, to cross-examine a witness. It's a probable cause hearing. And yet all the cases in the briefs, there's several of them in my brief where I cite that in fact, that is a sufficient basis. A motion for a new trial certainly has a much higher burden, the burden on the defense, to establish proofs to set aside a conviction, particularly in a case that's strong. So there isn't a finite list and a definite list when somebody's unavailable. A witness is unavailable because his employer won't let him testify. I can't subpoena him. He's out of state. We don't have the jurisdiction to bring him into court. And he's not, and he told me directly, I'm not going to give up my job to testify in this matter. Are there questions I can answer for the court? I don't know where I'm at on my time.
You're fine. Anything?
And is the reason you filed a motion in limine so that not only you would know in advance whether you were going to be able to use this testimony, but if you were not going to be able to, potentially you could try to find someone else?
That really is the bottom line problem for the defense here. The months that are necessary for an expert of somebody equal to or greater than Dr. Cole's list. First of all, we've got a half a dozen in the entire country. You've got to get them interested. You got to get them to spend the time. They have to look at a lot of this comes down to the slides from the pathology, white blood cells, how fast there's tissue injury, months upon months to get expert witnesses, number one, to review the material, meet with you, and then give you an opinion. And this pool is so small. There aren't experts better than Dr. Spitz or Dr. Diaz. And there's limited resources that a defendant has. We're not the government. We can't go out and spend an unlimited amount of money. I wish there were other experts, but I have not been able to find any so far.
And let me ask a follow-up question on Dr. Diaz. So the court says it's premature to declare him unavailable. So what is this? So if nothing changes and it goes back down, what does this look like with respect to Dr. Diaz? You subpoena him, he doesn't come, and then you do this again? Talk to me a little bit about the process ahead of you.
I don't know how the premature issue, I really struggle with, and I have tremendous respect for Judge Schaefer. He's a very bright judge. I think he made the correct ruling and set a conviction aside. But I would be exactly in the same position the first lawyer was. I'm going to be there on the morning of trial, and he's ruling on the morning of trial whether I can or cannot call these experts. And if he says I can't call these experts, I have no experts available, and it'll result in a conviction just the way the first trial did. And then I'm going to be the one that's ineffective because I don't have an expert to testify.
So it would go to trial, and that's when Judge Schaefer indicated that he'd let you know. He says it's premature on Dr. Diaz, but I'll let you know on the day of trial.
Well, to be direct to the court, I can't say he said I won't decide that until the day of trial. But the way I read his opinion that it's premature, I don't know when it would not be. I don't know when he envisioned making that ruling.
Well, you haven't
no,
subpoenaed him yet, right?
I have not.
Okay, so I mean, one time it could be mature as opposed to premature is you've already subpoenaed the witness and the witness is not here. Or, you know, right? Because right now we're in the pre-subpoena stage, it seems to me.
Well, as an officer of court, I guess to be direct, I hadn't really thought about that, but that probably would be in my course of conduct. Trial date gets set. I subpoena him. He doesn't show up. And now the issue would be ripe.
Or maybe even he gets the subpoena and he writes a letter and says, I'm not coming.
That would probably give me a little more advance notice, but I already have that. And I attached his affidavit. He affirms his prior testimony. It would be the same, but he cannot testify.
Can I just, and I'm sorry for keeping this
No.
going, but going back to Dr. Diaz's testimony at the Ginter hearing, one of the arguments that the prosecution makes is that they did not have the type of information, the type of disclosures about the experts before the Ginter hearing that they would normally be entitled to at trial, such as a summary of what the expert would be testifying to. Can you clarify what did the government have before the Ginter hearing about the two experts? Did they have CV? Did they have a summary of testimony? Did they have their name? Any or all of the above?
They did, Your Honor. It was over the holiday weekend that Dr. Diaz had the opportunity to review everything. And I'd been talking to him. I won't say stalking, but trying to pursue him for months previous that. I get a call from him. He's reviewed it and he supports Dr. Spitz because I'd given him the information from Dr. Spitz to see if he concurred or not. And he confirmed he would on January the 4th, the 23. So almost 3 months before the hearing, I disclosed Dr. Diaz as a witness that I would be calling. I actually filed a motion on January 4th to expand the record because now I have a second expert. And I gave that his CV is extensive. He's one of the best in the country. The government had that information on January 4th. That's when I filed it. So presumptively within certainly less than a week, the government had it.
So the government had his name and his CV.
They did.
Anything else?
Like a summary of what he would testify to?
Well, there were extensive discussions between the prosecutor and I. This was something, great deal of respect for Mr. Butler. Him and I were talking extensively. We both recognized what the issue was, but that's not on record. So I can only answer that for the court's discretion. And let me also point out that the government knew where we were going without a doubt by the March hearing. They could have recalled Dr. Cole. They chose not to. They could have recalled Dr. Spitz and chose not to. The government made tactical decisions how to approach this problem. And I don't think they can now use it as a shield to prevent me from doing this.
The trial court obviously hasn't set a trial date at this point, right?
It was put on the record at the March hearing that either party would be appealing the court's ruling, and the judge has been very accommodating and indicated he would grant us permission because this is the issue in the case. It is so important because there's so little evidence other than medical examiner's testimony. And it really does come down to what Dr. Diaz testified. Dr. Cole's opinion is there's a severe blunt force trauma. When you look at the medical exams, both of my experts are saying it is not severe. This is Ackley revisited, what this really comes down to. And that's why Spitz is so important, because the injuries that the child suffered were modest. They were minor. It's a shortfall. It's not a severe blunt force trauma.
Has the trial court said anything to suggest that if this were to go back and go for retrial, assuming you get to the point where it's no longer premature and it's determined, that Dr. Diaz cannot testify, that he wouldn't afford you time to find another expert? Has there been anything like that?
I can't recall that specifically happening. Again, it's a fascinating issue. The parties we've had open discussions with the judge. This is the issue in the case. And I think Judge Haver made an error in his ruling, but it's been very professional accommodation between the parties.
Okay. All right. Thank you very much.
Your Honors, thank you very much for court's time.
Thank you very
Thank
much.
you for being here, Mr. Stanley. That case is
thank you.
submitted. Moving to item number 16, case number 372-175, People versus Doug Arthur Wolschlager. I believe we have one endorsed party.
Good morning, Your Honors.
Good morning.
May it please the court, Ashley Siegel on behalf of defendant appellant Mr. Walschlager. I'm satisfied with the record here, including the briefings that this court has had an opportunity to review, and I'm happy to answer any questions.
All right.
I
Any
don't have any
questions?
at this
I don't
time.
have any questions. Thank you very much.
I have none either, but thank you for being here. Appreciate your appearance and your briefs.
Thank you, Your Honor.
All right, case is submitted. Item number 17, case number 367-258, People versus Christopher Allen Rice. I believe Ms. Young is appearing remotely as the only endorsed party.
Good morning, Your Honors.
Good morning.
Laurel Kelly Young on behalf of appellant Mr. Rice. And I just wanted to point out that I think the strongest issue is that we have testimony from the woman who owned the trailer that she did not give her ex-boyfriend permission to enter the trailer. And also, if it was Mr. Rice who entered, there is insufficient evidence that he had any kind of a weapon. I think that the injured party started out with, I didn't see anything, and it eventually developed into seeing something, but he still couldn't identify what it was. So that.
But there was testimony to suggest that the injuries he sustained would not have been caused by a bare fist. Isn't that fair to say?
That testimony was from a police officer, and I don't think that, and that was my second issue, is that he's certainly not an expert in determining, the injuries, the level of injury. So I challenge that as well, that testimony.
Okay. Any questions from the panel?
I don't have any.
I see none. Anything else, Ms. Young?
Nothing.
All right.
Thank you.
Thank you very much. The case is submitted. Moving to item 18, case number 371-096, People versus DePerion D'Anthony Deshawn King. And we have both counsel endorsed, both appearing remotely.
Yes. Good morning, Your Honors. Laurel Kelly Young on behalf of DePerion King. And we had an evidentiary hearing in this case where Mr. King testified he was there and that he showed a gun, but he did not shoot. And I guess what bothers me most about this case is that the deceased wife, and there's plenty of testimony and affidavits that state that his wife brought him the gun and that he was inebriated and he started waving the gun around. And that's when all the people at this block party started showing their guns. And then I guess Mr. Wilson shot. And then I guess they heard 30 to 40, I guess everybody at the block party had a gun, and they heard 30 to 40 bullets. But I guess it bothers me that Mrs. Wilson testified that she did not have a gun, she did not give a gun to her inebriated husband. And, based on that testimony, she sent a 21-year-old man to prison for the rest of his life based off her jury. So that bothered me a lot.
Is the only issue remaining ineffective assistance of counsel, and everything kind of flows from that?
Yes.
Okay, so I guess the question is, based on what you've just said, is there a
Mhm.
connection between that and ineffective assistance of counsel? Because there was a Ginther hearing.
Mhm.
The trial court, as I understood it, found both of the new witnesses to be not credible. And then based on that, decided that some combination of there wasn't deficiency by the trial counsel and or it wouldn't have made a difference to the outcome. So where was the error there, I guess? And is there something that you've just talked about where I'm just not making the connection to the ineffectiveness?
Well, that Mr. King he didn't testify on advice of counsel when he should have, because it was self-defense. He had a argument of self-defense. And I know that trial counsel did not watch the police interview of Mr. Perez, because Mr. Perez told a whole story about how the wife came to the argument and handed her husband a gun, and then he shot it in the air. So this is what he told the police shortly after the incident, and I don't see how that's unreliable. And also the trial court took issue with he didn't have an argument of self-defense because he showed his gun. Well, showing a gun is not deadly force. Shooting a gun is deadly force. But the judge said, well, he showed the gun, so there's no self-defense there. And I think that's an error.
All right. Anything further? You have
Not
time,
much.
you have time for rebuttal. Why don't we hear from Mr. Babcock and then you.
Okay.
Good morning, Your Honors. Russell Babcock on behalf of the people. Again, as Your Honor are aware, this did proceed to a Ginther hearing. It was before the judge who who presided over the trial. And again, as we've pointed out in our brief, and as of course well aware, the factual findings made by the judge is reviewed for clear error. And again, the question is not whether this court might have viewed the hearing testimony differently. The question is whether the circuit court's findings leave this court with a definite and firm conviction that a mistake was made. And I think in the opinion that Judge Borrello issued, he went through the evidence very clearly. All these facts that defense counsel has indicated as troubling, those were all presented to the jury. The jury heard it was provided testimony from at time of trial of the behavior of the victim. There was nothing kept from the jury with regards to these two witnesses. The judge explained very carefully that they just simply weren't credible. I mean, this co-defendant was at trial, was awaiting trial, and in fact, he didn't even take a no contest plea until after the trial involving this case. So, and even then, he wasn't willing to outright admit to his participation. And the fact that he would testify and he would put his own defense at risk, this just didn't seem to make any sense. And quite frankly, between the inconsistencies of the witnesses, I think the trial court did a very good job of outlining why there why they simply weren't credible. And they certainly didn't really add anything. In fact, if anything, they added some conflicting testimony as to what they observed and what the defendant now claims to have had. And quite frankly, Your Honors, as Your Honors are well aware, at the end of the people's proofs, there was testimony obtained from the defendant by his attorney and by the trial court, establishing that he had been carefully consulted on this, and he under oath, and he acknowledged that he was waiving or not. Was making his choice not to testify. So, again, Your Honors, this is not a situation where the jury was not given a complete understanding of the picture before it. It was. It saw the good, the bad, and the ugly of the prosecution's case, and the defense counsel did his best to punch as many holes into the credibility as he could, and without compromising or his client's right to remain silent and to maintain his innocence. So, unless Your Honors have any questions, we would simply ask that the court affirm the trial court's rulings and deny and reject the defense arguments and affirm the trial court's rulings. And with regards to the other issues of whether his attorney conceded his guilt, obviously his attorney did not concede his guilt. We'd rest on our brief. And with regards to the forensic pathologists, again, we've outlined our argument on that. We rest on our briefs. And so with regards to all three issues, we'd ask that the court affirm the trial court's rulings.
Thank you, Mr. Babcock. Any questions?
I don't have anything to.
All right. Any rebuttal?
Yes. Mr. King waived his right to testify based on the advice of his attorney. And his attorney told him he did not have a defense of self-defense. So knowing that, he didn't testify. I think the only way to win with a defense of self-defense is you have to testify. So the jury can hear from you what happened. So I disagree with the prosecutor in regard to him waiving his right to testify.
But was that one of the claims of ineffectiveness? I thought the claims were the failure to call those two witnesses,
Right.
according to Mora. There's the concession of guilt at closing argument. There's you didn't object to the expert. I didn't see one about not having good advice around self-defense or testifying. I mean, do those fold into some of the other somewhere else?
No, and as I was reviewing my brief yesterday, and I said that he had failed to call two witnesses, I should have said three.
Okay.
He should have called Mr. King.
Okay.
All right. All right. Thank you. And thank you both. Appreciate your being with us remotely, and that case will be submitted.
Thank you.
We're going to move to item 19 on the docket, case number 364203, People versus Kenneth Lawrence Thomas. We have one endorsed party.
Good morning, Your Honors. Alona Sharon on behalf of the appellant, Mr. Thomas. I'm trying to get over being sick. I thought I was, and then this morning woke up sounding like this. I'm going to do my best to hope my voice holds out. So I apologize if I need to step back
No
for
problem.
a drink. I will not obviously reserve any time for rebuttal. I'm only going to address one of the issues in the brief. I'm sure the court can probably guess which one that is, and that has to do with the request for the withdrawal of counsel that was made by trial counsel on behalf of both himself and Mr. Thomas. I do want to address some statements, allegations that are made in the prosecution's brief. And of course, if the court has any questions, I will be happy to do my best to answer those. The first thing that I want to point out is actually in the prosecution's argument heading in its brief to the court. And I think what's important, and hopefully this was prosecution says the trial court's denial of defense counsel's motion to withdraw some 4 months prior to trial was neither an abuse of discretion nor structural error requiring reversal. So the first thing that I want to clarify for the court is that while ultimately the request to withdraw was made 4 months before trial actually occurred, at the time the motion to withdraw was made, there were actually no future court dates, right? That's a fact that was stipulated to by the prosecutor at the Ginther hearing. There was no trial date, there were no pretrials, there were no status conferences. The court schedule was completely clear of any future court dates. And so I just want to make sure that that's clear for the court. Addressing more substantive matters in the prosecution's brief, at page 6, the prosecutor writes, at this first request, given an outspoken client, it was not outside the range of reasonable and principled outcomes for the court to deny the motion at that point in time. So I want to address that sort of allegation by the prosecution. First of all, there's nothing to suggest at the time of this request to withdraw that Mr. Thomas was a, quote, outspoken client. I'm not really sure what that means or what its relevance is to the trial court's actions that were taken when the motion to withdraw was made. The fact is that Judge Trusock's action was outside the range of reasonable and principled outcomes because he was required to make inquiry of Mr. Thomas about why he wanted his counsel to withdraw, and he completely failed to do so. I don't know if the prosecutor is trying to sort of latch on to the trial court, Judge West, who said or suggested in his opinion that Mr. Thomas was disruptive. But I do believe I point out in the brief that there is nothing in the court record to suggest that. What we have that happens at that hearing is that Mr. Anderson raises the motion to withdraw. He responds to the court that the motion is both on his behalf and the client's. The judge makes no inquiry of Mr. Thomas. Mr. Thomas does not interrupt in any way. And then Judge Trusock says, okay, we're setting this matter. Well, he assures Mr. Thomas of his trial counsel's competency or competence and then says we're setting this matter for trial. Only at that point does Mr. Thomas ask permission to address the court and then addresses the court. So he's not disruptive. It didn't in any way interrupt the judge from being able to make the required inquiry. So it was an abuse of discretion, and that is plain looking at the case law of Wilson and Williams.
Would you say that when a request for counsel's withdrawal is made and it's indicated that both the client and the attorney are requesting this, that the trial court has two independent obligations to both inquire of the attorney and then also, no matter what the attorney says, inquire of the client separately?
So my answer is yes. I have not seen any case law that explicitly says he has to make inquiry of counsel, mostly because that wasn't really the issue here, right? He did inquire of counsel. But the case law is unambiguous that inquiry, if the defendant makes the motion, right? And he explicitly asked, is this a motion being made by you, Mr. Anderson, or on both of your behalfs? And Mr. Anderson says, no, I'm making this motion for both of us. The judge is absolutely required when an indigent defendant makes that request to make inquiry as to the nature of the conflict and to try and determine how serious the conflict or the breakdown is, Your Honor.
Directly, one-on-one with the defendant without the lawyer being an intermediary.
I don't know that I would necessarily have, well, no, it is direct. The case law says that the inquiry must be made directly of the defendant. There is nothing that I've seen that suggests that the trial counsel may speak on behalf of his client when it comes to that, Your Honor. The prosecution also suggests that Mr. Thomas sort of created this conflict by refusing to cooperate and communicate with his trial counsel, and therefore he intentionally caused a breakdown in the relationship between himself and his trial counsel. But that is a misrepresentation of the facts and the record from the Ginther hearing. Trial counsel, Mr. Anderson, testified that, he never testified that Mr. Thomas refused to communicate with him initially. To the contrary, what his testimony was at the Ginther hearing is that it was just constant disagreement between the two of them, disagreement about trial strategy. disagreement about what the evidence meant, so on and so forth. It's only once they get closer to trial that this breakdown has become so exacerbated that there is just no communication between the two of them. Mr. Thomas doesn't trust his counsel, counsel can't communicate with him, and there's just a complete breakdown because it has continued to deteriorate over those 4 months leading up to trial.
I mean, one of the, and I'm sorry to keep
No,
interrupting you,
please.
but one of the things that I think is challenging here is that, to me, if what counsel testified to at the Ginther hearing had come out at the motion, at the motion hearing to withdraw as counsel, then we would be in a completely different world, because everything that counsel said at the Ginther hearing made it like really obvious what you just said, that there had been a complete breakdown in the relationship. But that didn't really come out at the motion hearing. And defense counsel didn't really say that at the motion hearing. There was something written in a motion, and there's a little bit of a dispute about whether the written motion actually got under the eyes of the judge before the hearing. But you know, there's the challenge here for me is that what the judge saw at the motion hearing wasn't what we saw at the Ginther hearing.
So, Your Honor, I will respond to that. I would respectfully disagree that what Mr. Anderson presented to the court at the time of the motion hearing would have been insufficient to grant the motion to withdraw. That's my first response. My second response, though, is that if you look at what Mr. Thomas offered at the Ginther hearing, right, that certainly would have been enough to grant the motion to withdraw, but he never got an opportunity to make that record. And that error falls on Judge Trusak. It is his obligation, Your Honor, under the case law to make inquiry. So on the one part, respectfully, Judge Karadkin, I disagree that what Mr. Anderson said at the motion hearing wasn't sufficient. And also, Your Honor, I think that had Judge Trusak engaged in his duty, then the statements from Mr. Thomas certainly would have been sufficient. And I can certainly see a situation where had he actually made the inquiry of Mr. Thomas and Mr. Thomas said, we don't agree on trial strategy, we don't agree on what the evidence says, that a judge would then necessarily turn back to Mr. Anderson and say, do you agree with this, right? Because you're joining in this motion. But that never happened because Mr. Thomas was never engaged with by the trial court. That is an error.
And just to clarify, there was no engagement with Mr. Thomas.
None.
Okay.
None. The only engagement comes, Your Honor, he has conversation with Mr. Anderson. Is this on behalf of both of you? He speaks. So I want to be clear on engagement because sometimes after Mr. Anderson tells the judge what the breakdown is, he addresses Mr. Thomas and says.
Anderson or court addresses Mr.
The
Thomas?
judge,
Okay.
Judge Trusak, addresses Thomas to say, I know your lawyer. He's been practicing for a long time. He's very competent. Sometimes you have to hear things from your lawyer that you don't like. I'm not granting the motion. We're setting it for trial. So if you mean engage in terms of question answer, there's no engagement.
That's
If you
what
mean
I-
engage in terms of did he speak
Address
to
him.
Mr. Thomas? Address him? He did, but in no meaningful way that he could get a response from Mr. Thomas.
And the case law is clear about what type of engagement.
Yes, Your Honor, and that's cited in my brief. It is a federal standard that our courts adopted back in the 1970s, Your Honor. And it requires, it requires inquiry. So to look at the timeliness, the adequacy, this is the review, sorry, the timeliness of the request, the adequacy of the inquiry, and the extent of the conflict. But the federal standard requires that if an indigent defendant makes this request, that the court is required to make inquiry to determine the good faith of the motion and to determine the reasons. So that's the requirement on the trial court, which I think everyone can agree Judge Trusak failed to comply with. Your Honor, the prosecution also cites to the Strickland case that a judge is not our common Strickland one that we use in ineffective assistance is a Michigan case, that a judge's failure to explore a defendant's claim that his assigned lawyer should be replaced does not necessarily require that a conviction following such an error be set aside. And that is the Strickland case is factually distinguishable from Mr. Thomas's case because what is clear in Strickland is that the trial court absolutely made inquiry of the defendant. He had accepted from the defendant a copy of a grievance that he had filed against his attorney. And so he became aware of his complaints by way of accepting the grievance. But also he explicitly asked the defendant on the record, is there anything else you want to tell me in addition to this grievance? So Strickland is factually distinguishable from this case and it should not be relied upon. And finally, in footnote 8 of its brief, the prosecution suggests that our Michigan Supreme Court in the Ginther decision distinguished the Williams and Wilson cases, which I heavily rely on in my brief, noting that in contrast to those two cases, the record in Ginther doesn't show that the lawyer assigned to represent Ginther was in fact inattentive to his responsibilities. And here's the problem with that. In Wilson and in Williams, there is no finding in either case that the error stems from the fact that the trial court made a finding that trial counsel was in fact inattentive. That is absolutely inaccurate. We have these two cases, Wilson and Williams. In Wilson, Your Honors, we have the case where the defendant alleges that his counsel was inattentive and disinterested. And the Court of Appeals explicitly says, we have no idea if these allegations are accurate, right? Because the trial counsel failed to make inquiry. And it is because the trial court failed to make inquiry that we are vacating his convictions, okay? Because it was an abuse of discretion and the court failed to make inquiry. So the court actually explicitly acknowledges that they have no idea if the defendant's allegations are accurate. That's Wilson. In Williams, the allegation had nothing to do with trial counsel being disinterested, but it was a complete breakdown between the attorney and the defendant one day before scheduled trial. One day, and the trial attorney comes before the court. It's the day of trial and tells the judge something happened yesterday and we just can't move forward together. So there is no finding in Wilson or Williams that the court made a finding of disinterest, that the trial counsel was disinterested. So that's a misrepresentation of the case law. Your Honors, I think it's clear here. I don't really think there's any question, just looking at the facts and the record that's made, that these two gentlemen agreed on nothing, not what the evidence meant, not the consequences of it, and not the strategy. It is a total denial of counsel. It is structural error. When you look at Wilson and when you look at Williams, there is no engagement of the court to try and determine if defendant was prejudiced. When you look at the federal cases that I cite, there is no analysis of whether the defendant is prejudiced. It is looked at as a total denial of counsel. It is structural error. And for that reason, Mr. Thomas's convictions should be vacated. Judge Karoff, you look like you have a question.
Yeah, I'm just, tell me again at the at the motion hearing.
Yes.
If Judge Trusock had asked Mr. Thomas, hey, what's going on?
Yes.
What Mr. Thomas would have said and how we know that. Because I was looking at the Ginther hearing transcript and Mr. Thomas was called.
Yes.
I think you were
Yes.
doing it. But there's not a lot there for Mr. Thomas about what was going on with his lawyer.
So Mr. Thomas, he confirmed that he and Mr. Anderson repeatedly got into verbal arguments during the representation. When he asked, he explained that they did not agree regarding trial strategy and that they disagreed about the evidence. That was his testimony.
Yeah. And I think we kind of have to assume that's what he would have said had he been asked by Judge Trusock.
I think that's
at
the
the
point
hearing.
of the
That's the
Ginther.
point of the Ginther.
Yeah. But again, Your Honors, just looking at what Mr. Anderson testified to at the Ginther hearing, right, is he also agrees that they disagreed about trial strategy. They disagreed about what the evidence demonstrated. Their arguments got heated at times. That's exactly the same essentially what Mr. Thomas says. But he also makes a record going forward, because it's something that wouldn't be obvious to Your Honors or to myself in the transcript, that this went on through trial with certain conduct by Mr. Thomas really trying to communicate to Judge Trusock that he could not communicate or trust his attorney. So I understand Your Honor's reservations, but the fact remains is that Judge Trusak failed to engage in what he was required to engage in. This court should absolutely assume that had he made inquiry into Mr. Thomas, he would have gotten that information from Mr. Thomas. I think absolutely it would be almost ridiculous to assume that after hearing that from Mr. Thomas, he wouldn't then turn to Mr. Anderson and say, do you agree with everything your client has said? And at that point, he absolutely would have had to grant the motion to withdraw. I also just want to know, and I do mention this in the brief, right? When you push trial counsel to give too much information at these motions to withdraw, right? We all know we have to walk a very fine line, right? I can't disparage my client and say, Joe Schmo is a total idiot and doesn't understand what the evidence says, right? And I can't say, well, I want to pursue this defense, but my client wants this to, I mean, that's all privileged. It's all privileged. So, and I know in the brief, you know, I try to look for cases where judges would deny joint motions for withdrawal. It just doesn't exist. And there's a reason it doesn't exist. Because when you have a client and an attorney who go to a judge and say, we are not on the same page, we cannot agree, it's an abuse of discretion to not grant that. And also having some sensitivity as to how much an attorney can say without piercing privilege, without being unethical. Your Honor, this error falls squarely on Judge Trusak. It is structural. Mr. Thomas was denied his right to counsel and his convictions should be vacated. Judge Young.
Yeah, so I think you just answered my question, but that is what I was going to say, which is the existence of disagreement on matters of strategy and the factual landscape happens with some regularity with appointed counsel. I think it's especially when you can't choose your counsel. I think that's something that happens. But and even when you can choose your counsel, I think that's something that happens. But you're distinguishing this from run of the mill, we see things differently, and is that it was joint, right? Because my understanding is that there's plenty of times of disagreement or misunderstanding of factual landscape, but what that looks like is usually just the client's motion and defense counsel to say, true, we disagree, but this isn't anything out of the norm for me.
I absolutely think that it takes it to next level. Having said that, though,
Yeah.
I don't think I need that to prevail in this case. I think the case law very much supports that this is an abuse of discretion because of Judge Trusak's failure to make inquiry, and that it amounts to a denial of counsel. Not only do our state cases indicate that, but so do the federal cases. And I'm not really a big fan of citing federal cases. I did in this case because our courts explicitly have adopted the federal standard. And for that reason, I think the federal cases are even more persuasive than general.
But it is the failure to make inquiry plus the content of it's not just the failure to make inquiry. It's the failure to make inquiry plus what we can assume he would have said by way of the Ginther transcript, right?
I think that makes it stronger, but I think if you look at Wilson, okay, in that case, his convictions were vacated simply on the basis that the trial court made no inquiry. That is what happens in Wilson. There is no factual distinction. Well, the only factual distinction between our case and Wilson is that here it's a joint request, whereas in Wilson, it was only the defendant, right? The defendant tells the trial court, essentially, my lawyer doesn't give a crap about me. He's not seeing me. He's not talking to me. And the trial court makes no inquiry and says, hey, I know this lawyer. He's great. He's been practicing forever. We're going to trial. I mean, almost verbatim what Judge Trusak says. And this court vacated and said, no, that's not okay. So that's exactly, I mean, there is no factual distinction other than in this case, you also have trial counsel saying, I need to be able to withdraw, which, right, makes it sort of doubly offensive that the motion to withdraw doesn't get granted, and even more problematic in terms of Mr. Thomas's Sixth Amendment right to counsel. Judge Karavkin?
No,
No, okay. I guess I thought you were
Satisfied. Thank
telegraphing,
you.
but not. If the court has no other questions, I obviously ask that you find that there was error, that it's structural, and vacate Mr. Thomas's convictions and remand for a new trial.
All right.
Thank you, Your Honors.
Thank you very much for being here. Hope you feel better.
Thank you, Judge.
And that case is submitted. Before we move on to our next item, if you will indulge us, we're going to take a brief 5-minute break and then we'll come back and finish the rest of the call, going right into our 11 o'clock call after we're done with the 10 o'clock call. Thank you for that indulgence. We're going to proceed on with item number 20. Thank you for being at council table already. That's case number 369675, People versus Genesis Kevin Xavier Lewis.
And good morning, Your Honor. Ryan Machasik on behalf of Mr. Lewis.
Morning.
And good morning to the panel.
Good morning.
This case is, I'm going to start because I received an order from the court asking me to address certain issues raised in the standard 4 brief. And I'm going to briefly outline my understanding of those from review. And the first one is that Michigan Criminal Jury Instruction 17.4 regarding mitigating circumstances should have been given. This was preserved and the trial court denied the motion for the instruction. The next is that there was ineffective assistance of counsel for failing to request 2 additional accident instructions, and that is 7.2 accident regarding not knowing consequences, and 7.3A accident, and that one goes to the specific intent required for the alleged crime. And then there is a 4th issue that I understand I'm to be covering today, and that is ineffective assistance of counsel with regard to failure to request assault with intent to assault with intent to commit great bodily harm, less than murder, as a lesser to the assault with intent to murder.
And just to be clear, I don't think our intent was to require you to address all of those in oral argument, but be prepared to address them. Court may have some questions. You can proceed as you wish.
Thank you, Your Honor. But I just wanted to make sure I had the issues framed properly.
Yeah, thank you.
And so I'm going to start with, if I may, with the error regarding Michigan Criminal Jury Instruction 17.4 mitigating circumstances. There are, I think, 2 components to this. I will address the court's rejection of that instruction first, and that is because I think that the trial court misread 17.4 and what it required. So the trial court said that it would not give the mitigating circumstances instruction because it was not instructing on voluntary manslaughter. It was only instructing on involuntary manslaughter. And the court
For the murder charge.
Yes, Your Honor.
Right.
And this went to I think it's subsection B or part 2, where it talks specifically about voluntary murder. However, I think the court misinterpreted that jury instruction, and it's because if we look at both the preceding paragraph and then the final paragraph of that instruction, it says that the defendant can only be guilty of the crime of assault with intent to murder if he would have been guilty of murder had the person he assaulted actually died, if the assault took place under circumstances that would have reduced it to manslaughter, then the defendant is not guilty of assault with intent to murder. And again, in the last part, subsection 5, it again talks about if it's reduced to manslaughter generally, then you can't find him guilty of a murder charge.
Do you have any sense of what, so the judge said, and the prosecutor argued, and then the judge agreed, well, we're not instructing on voluntary manslaughter for the murder charge, so we shouldn't or we won't instruct on mitigating circumstances for the AWIM charge. Do you have any sense of why there wasn't a voluntary manslaughter instruction on the murder charge? Because it seems like if there was enough for a mitigating circumstances instruction on the AWIN charges, there, based on how this crime took place, there would have been enough also for a voluntary manslaughter charge, voluntary manslaughter instruction on the murder charge.
And Your Honor drags me to part two of my argument
Okay.
regarding 17.4.
Okay.
And that is that trial counsel should have raised volunteer or should have requested a voluntary manslaughter instruction. And I would point to the recent Supreme Court order in People versus Christopher Harlan Josell. It is Supreme Court number 167705-6. And after I received the court's order and I was aware of this very recent opinion, I sent that over to trial counsel and said, would you have requested a voluntary manslaughter instruction had you had this opinion in your possession? And he sent back literally 100% yes.
You know, we're not really supposed to consider that.
I appreciate that, Your Honor.
But you're aware of no reason that we don't know about of why a voluntary manslaughter instruction wasn't given for the murder charge. Is that fair to say? And we'll ask your opposing counsel as well.
That is fair to say. I recently addressed this with trial counsel. There is no reason that I'm aware of that this should not have been given. And I would point out, nothing in Josell is new law. Clearly, there are some disputes regarding the parameters under which a voluntary manslaughter instruction can be given, even after Yeager. But nothing is new law. However, it does synthesize it kind of in a more direct and new way. To that end, Your Honor, I should have identified as appellate counsel and raised this issue, and I did not. And so what I would ask is that the court would either for this and one another issue that I'll address later with the GBH instruction, but either remand for a Ginther hearing or allow me to supplement with the voluntary manslaughter argument the appellant's brief, because it is something that should have been raised. And like I say, this is nothing in Josell is new law. It simply puts it in a new light.
Hypothetically,
Yes, Your Honor.
if there were a Ginther hearing, which has not been requested as far as I know, but if that were something that were to happen, what would happen? Like, you would just call trial counsel and say, why didn't you ask for a voluntary manslaughter instruction? And trial counsel would say it was a screw up. There was no, I mean, what would be the purpose of a Ginther hearing as opposed to just sort of saying now looks like someone screwed up?
To be fair, and I would anticipate that at a Ginther hearing, trial counsel would simply say, I messed up. Okay.
Yep, fair, thanks.
And so, well, two lawyers now on that issue have messed up, both trial counsel and myself. But it is a significant issue. And especially in a case right here where very little was actually in dispute, right? There was video, there were multiple witnesses. My client testified in his own defense. And it really did come down to the issue of what was going through his mind when this happened. And so, you know, for that reason, it is really significant that voluntary manslaughter instruction wasn't given, because now the jury doesn't have an alternative to the second-degree murder charge. When my client, for example, testified, right, I did not intend to kill Mr. Acklin. I was trying to get these people right for context, because cases tell us to read everything in context. After there was a de-escalation from a prior fight, people go to their own corners. 3 men, half my father's age, jump him in a parking lot and start viciously beating him. That's when I pull my gun, and my whole purpose is just to get them off of my dad. it freaked me out. I'm not used to seeing, I think part of it was I'm not used to seeing my dad in that kind of position, being beat up by these three guys. And so, right, that had also had the voluntary manslaughter instruction been given, as it should have, it is certainly supported by, some evidence in the record, then 17.4, I think also would have been given. Your Honor, there is, if I may move on to the next instructions on this, are any other questions on the 17.4 or voluntary manslaughter? I will move on.
Sure.
Thank you, Your Honor. The next is going to the 7 series instructions. And here, right, especially as I look at 7.3A, action as it regards specific intent, that requires that, or it instructs that the defendant says that his conduct was accidental. If he did not intend to kill, then, right, he is not guilty. And here that was his testimony in his own defense. I did not intend to kill anyone. My whole intent was just to get these people off of my dad. And then that dovetails with the claim raised regarding failure to ask for a lesser included of the great bodily harm as an alternative to the AWIM charge, right? And the difference being that, right, there's no intent to kill. And again, that is the defense, right? That is why presumably Mr. Lewis took the stand in his own defense, and it was to tell the jury what was going through his mind. He did not intend to kill anybody, certainly not his friend, Armini Acklin. And so each of the instructions that he has raised are supported by testimony in the record, and should have been given. Some of those are attributable to the trial court, and some are attributable to IAC claims. With the court's permission, I will now move on to a couple of the points that I want to raise from the opening brief. Thank you. And that is the refusal to allow cross-examination of Mark Wilkerson Allen regarding some payments he received. There seems to be an impression that because this was through a statute, you cannot question a witness about that. But whether this is pursuant to statute, one, there was no evidence in front of the jury regarding that, but the trial court interjected, this is completely appropriate, effectively telling the jury that there's nothing wrong with Wilkerson Allen getting about $9,000 from the state. But what controls that analysis, it's not what the money is for, it's what the witness's perception is. And so when the trial court jumped in and sua sponte effectively instructed the jury that this is completely legit, regardless of what is in that person's mind. And again, this is right, a very hostile witness who is fighting with defense counsel, clearly has, right, some biases that Mr. Lewis was entitled to bring out in front of the jury. And so when the trial court cut off, right, the ability to get to the witness's state of mind regarding what that money was for, and I would point out, no medical bills had been submitted, right? So these are purportedly for medical bills. To that point, none had actually been submitted to substantiate his request, but it is his expectation of money and what that is for that governs the relevancy. It's not the statute or what the court was going to instruct the jury about. That also goes to, let's see. And again, this is Wilkerson Allen. He had a prior inconsistent statement regarding how the decedent Armini Ackerlin was shot. And he denied indicating to Maya, who was Mr. Lewis's sister, that this was actually because, right, of him fighting with Acklin. There was a tape, Defense Exhibit B, which was the trial court did not allow in, which had a prior inconsistent statement. And so we have multiple ways in which the credibility of a pretty key prosecution witness could have been attacked, and defense trials attempts to point out to the jury that this person lacks credibility were thwarted at every try.
So there were two potential errors there. One is the victim compensation fund issue, and then one is the tape, the recording.
Correct.
The inconsistent statement. Assuming we were to agree that those were errors by the trial judge in terms of the exclusion of evidence that should have come in, I'm not clear really on, so then we would do like a harmless error type analysis. And I'm not super clear on what that would look like. Because as you even alluded to, the facts of this case are somewhat like, they're not really in dispute in the sense of like who shot whom and, you know, what was going on. So what is it that made that witness's testimony so key, that if this impeachment had been allowed on those 2 points, we would have seen a difference in the outcome?
Okay, and Your Honor, part of it goes to the fact that this was it's a self-defense case, right? And so we have Mr. Wilkerson-Ellern putting himself almost in a sheepish position throughout his testimony, right? He downplays or denies his role as aggressor, as the person who is fighting, who is part of the group that re-escalates after everything is done in the initial confrontation with my client, who re-escalates by attacking Jerome Lewis and going over to that fight. So the context of what he provides really is relevant, especially because it is a self-defense case. For example, I would point the court to, where is it? Pardon me, one moment, Your Honor. Thank you. That is right. It is the fact that Wilkerson-Allen's testimony goes against, and is used in argument to undermine a self-defense claim, or a defense of others claim.
Defense.
And so his credibility and the extent to which a jury believes his testimony really impacts how much they're going to believe that Mr. Genesis Lewis, my client, was acting in defense of his father when he acted. And so I think that's how we get past the harmless error issue. I will comment briefly on, if I may move on, on the trial penalty. The prosecutor points out in their response brief that the trial court, Judge Trusak, made no comments regarding the fact that he was penalizing Genesis Lewis for going to trial. That I do not read that to be the standard. I think that the court can look at the sentence and everything that went on in context. There is nothing that came out after that offer was made, remade, that would have served to increase this sentence by 50%. And it's in that context that I think the court has to read it. Otherwise, I don't know of many judges who, if they were imposing an unconstitutional trial penalty, would say, you better not go to trial in my court. Actually, no. One time in a hallway, I had a judge say that to me. But I cannot imagine that on the record, any trial judge is going to say, you'd better not go to trial in my court, lest we are going to increase your sentence by 50%. Because there were no new facts that came out that were available to the trial court when it sentenced, as opposed to when that initial cause was made, I think that the court should read that to be a trial penalty or a vindictive sentence. And unless there are any other questions, I will sit in my chair.
Questions? Thank you very much.
Thank you.
You have time for rebuttal.
Thank you.
Response?
Yes, Your Honors. Good morning, Katie Went with the Kent County Prosecutor's Office on behalf of the people. I'm going to touch on some of the questions that Judge Krobkin has asked of defense counsel, but of course I welcome any other questions. As it relates to the issues raised by counsel with respect to your questions regarding harmless error, I just want to point out before I get into the actual analysis of each of those issues, that this isn't a he said, she said about what happened during this fight, right? The court has had the opportunity to view videos, the exhibits. The jury had the opportunity to view this fight from multiple angles. So this isn't an issue of what Mr. Wilkerson Allen saw versus what defendants saw. And so I think that takes, that eliminates part of the credibility argument that defense counsel is making here. But then when we look to these specific errors, one of the errors that defense counsel talked about today was this issue of impeachment and using the exhibit B to impeach him in his own words, as opposed to using the defense's witness, Maya Lewis. At the time that Judge Trusak said that the exhibit wasn't going to come in as impeachment evidence, Maya Lewis had already testified to the statement, the prior inconsistent statement made by Mr. Wilkinson Allen. So he had already effectively been impeached. Certainly, he could have also been impeached through that recording. But when we look to whether or not this is harmless error, and I'm not conceding error in this respect, but when we look to whether it's harmless, that fact of what he said was already presented to the jury. So I don't think we could ever get over that harmless error hurdle with respect to that specific evidence.
But don't most jurors, wouldn't most jurors rather hear a recording of someone saying something than testimony that someone heard them say it?
Certainly, Your Honor, I would concede that point, that an exhibit of the person actually saying it in their own words would be more effective than the witness saying it. But I don't think that that was even a point that the prosecution disagreed with, that he said that. I don't think the prosecution really took Maya Lewis and tried to make her look less credible based on that point. I think that that was just an accepted prior and consistent statement in the record, at least based on my review, if I recall correctly, Your Honor. But at the end of the day, I think it is cumulative. I don't think that that would tip the scales in this case, even if Mr. Wilkinson Allen had been impeached through his own voice rather than Maya Lewis's statement. And with respect to the CVSC claim, I'll maintain my position that that was not admissible evidence to begin with. But what the jury heard was a question to Mr. Wilkerson Allen. That is a very tough name to say. It was a question to him of whether he submitted a claim. There was no question of whether he actually received a benefit in exchange for his testimony. Had the court allowed more questioning, even against the statutory instruction that this was inadmissible evidence, the jury would have been able to hear more about the process of a CVSC claim, what that means for a victim of a crime, that a victim has the entitlement to submit that claim, and then that claim is assessed completely separate from the jury trial itself. And that's why this is inadmissible. That's why jurors don't get to hear about this, because it has no bearing on the ultimate guilt or innocence. This isn't akin to the prosecution giving a benefit to a witness in exchange for their testimony. This is a statutory right that victims have. And that's why jurors don't get to hear about it, because it would be so prejudicial if they got to hear about this, because it's completely unrelated to the defendant's guilt or innocence.
Several other state courts have said that this stuff comes in under Davis versus Alaska, the confrontation clause. So I mean, it may be harmless, but if a witness is getting paid, you kind of get to ask the witness about that.
So, Your Honor, I think and I apologize, I am not as familiar with Davis versus Alaska as I should be at this moment. So I'm not going to pretend like I know the holding of that case right now. But I would think that there's a difference between a witness being paid for their testimony and restitution, and the statutory right to restitution. There's the cases that I cited in a footnote in my brief about that not really being relevant to a witness's bias. But then the direction that we get from our legislature in the act that allows them to submit a CVSC claim is that this is inadmissible in a trial. I don't know how we get away from that legislative directive when we're looking at admissibility here. But I agree with Your Honor that even if we see differently on the admissibility of it,
I don't believe that harmless error has been established here based on the question that was asked and based on how we can imagine the questioning would continue if they were allowed to go down that road. I think that the prosecutor in this case would have been able to rehabilitate the victim or Mr. Wilkerson Allen in that respect. I'm trying to use names because there's multiple in this case. So I don't think that that would ultimately impact the outcome of trial here. Are there any other questions with respect to the claims raised by counsel before I move on to the standard 4? With respect to the standard 4, I'll also start with the mitigating circumstances instruction. And Judge Krabkin, you had a couple questions for that as well. And one of them was a question of why was a voluntary manslaughter not requested? And to be frank, I don't know. I scoured the file for this. I scoured the record to figure out, was that ever discussed? Was it discussed why involuntary manslaughter was requested instead of voluntary manslaughter? And there's just simply nothing on the record that I can tell. But I think what's important, getting to your second question of what would happen at a Ginther hearing, that we can't ignore the fact that an involuntary manslaughter instruction was requested and given to the jury. So the jury did get to consider that lesser included, and they still chose to convict of the greater. Now, I understand involuntary is different than voluntary. There's different elements to those two crimes, but this isn't an instance where trial counsel decided not to request a lesser on that murder at all. So we would have to dive into why involuntary versus voluntary. But I would pose to this court that we're not here to discuss that instruction. That was a request made today to this court on an ineffective assistance of counsel based on the failure to request a voluntary manslaughter. And of course, we have to follow party presentation principles. That wasn't raised in the briefing. That's not been an issue before this court today. So when we look to 17.4, the murder is not at issue here. That 17.4 only relates to the 3 AWIM charges. So even if this court were to agree, and I'll get into my argument as to why I don't believe that that instruction was warranted, but even if this court were to agree, we're not here on that 17.4 to disrupt the murder charge. That stays because there was no voluntary manslaughter instructed. That was not an issue raised on this appeal. And that's not, frankly, an issue that we're here today to discuss. So
I mean, you're right that that wasn't, it doesn't seem that that was requested. The reason it seems like they're linked in some way, and what way that is, I think we're trying to figure out. But when 17.4 was requested, the trial judge's only reason, it seemed to me, for not giving it was, well, we're not giving that because that's the analogous, that's akin to a voluntary manslaughter charge. And we didn't give voluntary manslaughter, so we're not giving mitigating circumstances. So it seems like in some way they kind of go together.
correct.
And so if that's really the reason, it begs the question, well, why wasn't there voluntary manslaughter?
Correct. Your Honor, I completely see where you're coming from in that because it doesn't make much sense to me why counsel would request 17.4 on mitigating circumstances and not request it on the voluntary manslaughter on the greater charge. The only thing I could think of in preparing today and really thinking through this is that if the jury agreed on 17.4, so if counsel had been successful in getting that instruction read to the jury on the AWIM charges, then, and the jury agreed on mitigating circumstances, then his client would have been fully acquitted of the AWIM. There is no lesser, there's no assault with intent to commit voluntary manslaughter. So his client would have been fully acquitted. Whereas had he requested a voluntary manslaughter instruction on the murder, that's a lesser included. And he already got a lesser included in the involuntary. So he's not looking at the difference with the AWIM of conviction versus acquittal, if he gets this instruction. Had he requested on the murder, it's murder versus voluntary manslaughter. And if you recall from the transcripts, counsel argued to the jury, he didn't make the argument, hey, convict him the lesser, not the greater. He said, this isn't murder and this isn't involuntary manslaughter. This was a defense of others argument. This was an all or nothing argument for counsel of my client acted in defense of his father. You should believe that. And if you believe that, my client is not guilty of anything that we're here for today. So I think that it's the only thing I could rationalize in my brain was that 17.4 would have led to a full acquittal as opposed to a lesser. And of course, we don't have a record to get us there. And as Judge Krabkin, you noted, there hasn't been a request for a Ginther hearing. So we're looking at what can we conceive and can we conceive a legitimate strategy from what the record we have. And of course, this was 17.4 is a preserved issue. So we're here to discuss the trial court's error in that, well, the alleged error with respect to that. So I agree that we are procedurally in a confusing state because of the voluntary manslaughter not being instructed or not being requested. But when looking to whether or not voluntary manslaughter, or in this case 17.4, was appropriate, this court can look de novo review. So we're not looking necessarily just at those, the trial court's explanation, but should this instruction have been given? And I would submit to the court that the facts in this case do not support a voluntary manslaughter or a 17.4 instruction. And the reason being, if you look through when defendant decided to get his gun, I know I read through Jostle and there's some cases in there, and I'll admit to this court, there's some cases in there where a defendant was in a fight, removed themselves from the fight, and came back and used the gun, and that was said to be voluntary manslaughter. So I read through those cases to try to decide, is this case different? Or is this one where I put my hands up and I say, there's error here? But I think it's different. And this is why. In those cases that are cited by the court, there are 1,800 cases from the Michigan Supreme Court. The act that caused the provocation happened before the defendant went to get the gun. In this case, if you read defendant's brief, what he says to you is that it was seeing my dad jumped that gave me that provocation. Well, when you watch that video, and I would encourage the court to go back and watch it again, he goes back to his car to grab his gun at the second his dad re-engages the fight. He does not wait to see his dad get jumped to make the decision that he needs to bring lethal force into this fight. He makes that decision before the alleged provocation occurs. And then when we get to that decision to use the force, he testifies that I reasoned in my head, I have 2 guns in my hands. I'm going to make the conscious choice to use what I believe to be the less lethal option, which was the one with the hollow rounds in it. So he made a conscious reasoned decision of which gun to use and which gun to bring to this fight. I don't believe that is the heat of passion that takes away your reason. I don't believe that that's what we're looking for when we're looking for a voluntary manslaughter instruction and adequate provocation. And I also don't believe that this is like Jostle, where the court said, well, there's some provocation and whether or not it's adequate is for a jury. I think we're completely outside of that because of the time when defendant decided to bring lethal force into a fist fight. So whether or not we're looking at the decision on the murder versus the manslaughter and the AWIM versus 17.4, I don't think had counsel asked for a manslaughter instruction, he should have been given it because I don't believe it was supported by the facts. And I don't believe the trial court erred in failing to give an instruction under 17.4, even though the trial court's reasoning might have been a little confusing to all of us. Looking at de novo review, I don't believe that that was error. Any questions on that before I move on to the other instructions?
Just for clarity on the record, you said a gun was obtained after dad was jumped?
No, I believe the gun was obtained before dad was jumped. So I believe, based on my viewing of the evidence, I believe that they all disengaged from one another. And then some of the wedding party members shouted out a couple threats. And then dad went back and I believe started punching some people. He re-engaged the physical part of the fight. And as dad was re-engaging the physical part of the fight, I believe our defendant then went and got the 2 guns from his vehicle, walked about the 20 feet to do that, and came running back with the weapons. And then that happens it flows into each other. He comes running back with weapons and starts shooting.
So there's ongoing verbal threats and mutual assault with this individual's dad and how many other people?
There were many other people here. I think in that instance, I think there were 3 others from the wedding party, and then our victim who passed was also engaged in that as well. So I think there were 5 in that group that was ultimately shot at, Your Honor.
And that to you is a meaningfully different factual scenario than Joselle?
I do believe it is. I do believe it is, Your Honor. And the reason being that when you're looking at the facts in Joselle, the defendant in that case was trying to disengage. Defendant in that case had admittedly been involved in quite the series of events leading up to that, but he was trying to walk into his apartment, and that's when the victim came in after him. He was trying to get his key. She pushed him against the mailboxes. He fell into them, and he had a knife in his hand, and he stabbed her. With respect to whether that's adequate, I believe the court in Joselle said that should be submitted to a jury. When I'm looking at our case in comparison, defendant was not trying to disengage from anything. He was actually bringing more force than necessary to this. And when you look at his argument as to what he's saying was provocation, he had already made the decision to grab the guns before that.
You don't think that you don't think that going to get the guns could have been part of the acts that were undertaken in a heat of passion?
Under these circumstances, I do not. I think that there is case law, and as I recognize to the court, and I'll concede to the court, there is case law that under some circumstances, removing yourself and going to grab a weapon and coming back can provide circumstances for voluntary manslaughter. I think the difference is that in those cases, what provided that act of provocation, or the provocation that happened before the decision to go get the guns. In this case, we have everyone disengaging from an argument, dad going back in for the fight, and son, our defendant, going to grab his guns to essentially, the way I view it, is escalate the fight. With respect to the other instructional errors and claims of ineffective assistance of counsel, I noted defense counsel didn't touch on the transferred intent issue. Is that an issue that's this court would like me to spend any time on, or move on to the ineffective?
I think we got that one.
Yeah, I'm
Okay, gotcha. With respect to the ineffective assistance of counsel, and I'll start with the defense of accident instructions. In this case, of course, defense counsel did request an instruction under 7.1, but the claim is that he should have requested that under 7.2 or 7.3a. The trial court, in no unambiguous terms for this specific instruction, said, I don't think there's anything that shows that this was an accident. I think it's tempting to conflate the accident of the victim with the accident of the conduct. The prosecution in this case has never contended that defendant intended to kill Mr. Acklin. The theory was one of transferred intent. So I think that this term accident is becoming conflated with, I didn't mean to kill my friend versus I didn't mean to shoot my gun. His testimony is pretty clear that he intended to shoot his weapon because he was trying to defend his father.
But the jury got the involuntary manslaughter instruction.
Correct, Your Honor. Correct. The jury did get instructed.
Usually get that if there's some evidence that it was not an intent to kill, but a gun went off or whatever.
Yeah, and when I was looking through the record as to the theory behind why that was given, again, that's not
clear
on the record. So it's not clear why the defense requested, or for all I know, the prosecution might have requested. I don't know because both parties argued against it.
We've certainly seen cases where everyone is a little confused about whether the correct instruction is voluntary or involuntary manslaughter, and they choose the wrong one, and then we're kind of, what do we do? Because it's really the theory that they all had in mind was the other one.
Right, and I think if you read through the statutory involuntary manslaughter instruction that was given, just trying to put myself in the place of the attorneys that were handling this trial, it's very clear of he had a gun, he pointed it at someone, the gun discharged, and someone died. Right? It's kind of factually these things happen. There's really no intent element, as Judge Kropkin, you pointed out. I don't know if that instruction was given under some misunderstanding, or if that instruction was intended to say that this was accidental, but I don't believe the latter is true because of the discussion that the parties had with respect to 7.1. The prosecution obviously strongly opposed that this was accidental, and the court agreed that there was no evidence supporting that instruction. So my argument to the court would be that these instructions, it wasn't ineffective to fail to request this under 7.2 or 7.3a because the result would have been the same. No evidence to support that this was an accidental, regardless of the fact that of how the involuntary manslaughter instruction got in there. And then with respect to the GBH, the great bodily harm instruction, and ineffective assistance of counsel there. Again, we don't have a record, so we're looking at, can we conceive of a legitimate trial strategy based on these facts that we have before us? And there's plenty of case law from this court that says we don't need to give, that it's a legitimate strategy to not give the jury an opportunity to compromise. And even though they were given a lesser included with respect to the murder, I think that the assault with intent to murder is, it was reasonable to leave that as the only charge that this jury was to consider, because that requires the prosecution to prove an intent to kill. which is a lot more difficult than proving an intent to do great bodily harm. So in this case, it is a legitimate strategy to say, hey, even if you don't believe defense of others, even if you don't believe my client was acting to defend his father, there's no way the prosecutor proved that he actually had the intent to kill in this moment. Giving the jury a GBH instruction would have allowed them the opportunity to convict the defendant of something still coming out with a crime as opposed to an acquittal. Because I don't think that there's any way a jury wouldn't say shooting 13 rounds into a group of 5 people didn't at least have the intent to do great bodily harm. So I think this is a legitimate trial strategy based on the record. And I also don't think that they can establish prejudice when you're looking at the record and the jury's verdict is well supported by the record evidence. Does the court have any other questions? I know it's been a long morning, so I don't have any.
All right, thank you very much.
Thank you.
Very helpful. Rebuttal, Mr. Case?
Thank you. So to the newer points raised, there are a couple of things that I would like to respond to. One is a rejection of involuntary manslaughter does not tell us that a jury, the case law is replete, does not mean that the jury would have rejected a voluntary manslaughter had that charge been given to them. Some of the factual distinctions that my friend makes in her argument, I would point out for one of them that she thinks that the counsel thinks that the outcome depends on the fact that Mr. Lewis is alleged to have gone back to his truck before the second altercation started. Mr. Lewis' testimony is very clear. When he saw his dad getting beat, that's when he went back to get the guns. The difference is an officer was then called to interpret the videographic evidence and claimed that he saw something else. But on the basis of Mr. Lewis' testimony, and I think the video, when you watch it, his statement is true. Regardless, I don't think that that is outcome determinative. And while I know that my friend indicates that some of the cases cited by Giselle are oldish, they have recently been renewed in vigor within the last 30 days, Michigan Supreme Court opinion. One of them I would point to is on page 5 of Giselle, and that is Holmes at 111 Mich at 367 to 369. And the court points out.
What year was that?
I would have to go further up.
Okay, if you don't have it, that's all right.
It is, but the court notes in that case that the decedent punched the defendant 3 or 4 times after a scuffle in a boarding house. Boarding house makes me think it's older.
Probably older.
After which the defendant retrieved a revolver from his room and shot the victim 3 times. And so, right, even under the cases that are cited in Giselle, and longstanding Michigan Supreme Court precedent, even had Mr. Lewis gone back to retrieve the gun while his father was getting into the confrontation, but before these people had started their vicious beating of him, that is not outcome determinative. My friend indicates that they had disengaged and that's when he started shooting. That is demonstrably not the case. Look at the video. The initial altercation between Wilkerson Allen and Genesis Lewis, they had disengaged. Wilkerson Allen wandered off now, and he is with Caldwell and Suttles, and I can't remember the third gentleman's name, but now with the group that is surrounding and threatening. Right, and we have the issue with the interpretation of the threats through Jerome Lewis, but now threatening Jerome Lewis, surrounding him, and they start, right, beating him. They gang up on him. And so there's not a disengagement. In fact, right, they go over and they start a new fight, ganging up on my client's father. And so that is a big difference between this fight is over and they have disengaged. And with that, I will ask if the court has any remaining questions.
I see none.
Thank you. And
Thank
Your
you
Honor,
very much.
because this is an unusual circumstance, may I ask the panel for permission to brief the voluntary manslaughter issue, or am I required to file a motion to supplement?
Something you wish to see?
Why don't we talk about it and we'll let you know.
Let
If we
you-
want one, we'll order it.
Very good. Thank you, Your Honor. Thank
Thank
you,
you.
the court.
Thank you both very much. It was very helpful and we really appreciate you coming and being prepared to address those additional issues that we asked you to address. So,
Thank you.
and that case is submitted. And we are going to move on to item 21 on our docket, case number 372764, People versus Armonte Javan McCaleb. Ms. Went, you can remain there. And we'll welcome Ms. Owens.
Thank you, Your Honors. May it please the court, my name is Mary Owens, and I am just here for questions.
Okay. Any questions for Ms. Owens?
I don't have any questions. Thank you.
I have none either.
None? Okay, very
Thank you
good.
very much.
Thank you.
Good morning, Your Honors. Katie Went again on behalf of the people. I
Good
will-
afternoon. That last one took so
I-
long. We're now. in
You
the-
are correct. Good afternoon now. I apologize for that. I do want to say thank you for the order in that case. That does help us as parties prepare and know what the court, especially in standard four. So I do want to say that to the court, but I'm here to just answer questions as well on this case that the court may have.
Questions?
No, I don't have any.
No. And I have none, and I think that means there's nothing to rebut.
Thank you, Your Honor.
Thank you both for being here. Case is submitted. And we're gonna move right into our 11 o'clock call with item number 22, case number 375853, Stacy Robach versus Michael Robach.
Your Honor, if I may be formally attend, Emily Raxford for Ms. Maria. We have not requested.
Would you come up here, please, so we can pick you up on the mic? Thank you.
We do not have oral argument today, but we are here to answer questions, and I just wanted to let you know. that
Correct.
we're
Thank
back
you. You're
there.
right. I see that in my notes, and
Okay, would you prefer that we sit at council table or remain in the galley?
you can sit at council table. Thank you for asking that.
Okay, good afternoon, Your Honors. Justin Allen for the appellant, Michael Robach. I do have a few points I want to cover in addition to the briefing. This appeal is about whether a circuit court can freely set or can set aside a freely negotiated stipulated court order under MCR 2.612C1F without applying the mandatory three-factor test that this court, the Court of Appeals, has repeatedly required in the past. In this case, the parties negotiated a healthcare cost-sharing order in October 2022. They operated under that stipulated order for over 2 years. The plaintiff appellee used the agreement for her own benefit throughout the years. And then when the appellant sought to enforce its liquidated damages provision, the opposing side sought to move that stipulated order aside with the court. The circuit court granted that motion without making any of the findings required under MCR 2612C1F, but under MCR 2612C1F. It didn't find.
So let me just stop you for a second, because you started out saying this case is about whether the trial court can properly set aside a stipulated order without following the three requirements.
Yes.
And I guess I would ask, aren't there, I know you've characterized this as a motion under MCR 2.612C1. But aren't there other bases that the trial court could find independent of that, such as unconscionability of the agreement, independent of that court rule?
No, Your Honor. No. When setting aside a stipulated court order, MCR 2612 controls. There are a set, and I think it's very clear from both the language of the Michigan court rules itself and then subsequent authority in interpreting that. And so I think underneath the framework of MCR 2612, there are factors which the court could analyze, which may incorporate unconscionability. But that's not what occurred here, because the court didn't rely on MCR 2612C1A through E. It instead went to C1F, which requires the three-factor test. I mean, that's what the court did in making its ruling at the hearing. And in so doing, it didn't find that the reason for relief does not fall within the other subsections of MCR 2612C, which it was required to do. It didn't make a finding that my client's rights, substantial rights, will not be detrimentally affected, which it was also required to do.
Suppose the claim, the defense was unconscionability, which that was a defense that was asserted. It was just that the trial judge said, I'm not going to reach that.
Yeah.
Suppose that the trial judge were to examine that. Under what would that, how does that fit in with the relief from judgment rules? Would that come in under one of those subsections, or would that be kind of a whole separate? And I think Judge Boonster is getting at this too. Maybe it's like where do the pieces fit together in terms of defenses to what would otherwise be just sort of a breach of contract claim,
right?
When you're talking about what's both a contract and an order.
I think under the authority that I've found and reviewed on this point, I think the court rule and the authority which interprets this document as a court rule or as an order first is what applies. And for that reason, just general unconscionability or general equitable principles do not apply. I mean, MCR 2612 it exists for a reason, and the reason is to guide courts in how they go about potentially setting aside court orders when requested by the parties. I would agree with your honors, if this document were only a contract rather than an order to which contract principles of interpretation apply, perhaps general notions of equity or general analysis of unconscionability may apply, but that's not what we have here. And I have not seen authority which suggests that the general principles of contract interpretation, which do apply when determining how the order should be interpreted, trump MCR 2612 when a trial court is tasked with analyzing whether or not an order should be set aside. And so I don't see that changing the analysis with respect to the arguments we raise in our appeal. And I would also add, I mean, for good measure, and we do include this argument in our appeal brief, even if unconscionability is what's examined, unconscionability needs to be examined at the time the parties make the underlying agreement. And I don't think there's any question from the record or from the representations of either party made in the briefing that the agreement was made voluntarily by both parties at the time, that the stipulated liquidated damages provision, which my client sought to enforce against the opposing party, was in fact suggested by the opposing party to begin with. And so if we focus in on that unconscionability analysis, I think it rings hollow when applied here under those principles of contract interpretation. But with that said, I mean, our position is that MCR 2612C1F should apply as the court itself said it was applying, despite the fact that it failed to analyze the individual factors. And I would add, I think I mentioned the first two factors already. The third factor required under that framework is whether extraordinary circumstances exist mandating relief to achieve justice. That wasn't analyzed by the court either, and we would argue that that factor is not satisfied. Now, with respect to more specifically analyzing the specific three factors, factor one, the court made no finding. The court stated reasons that the stipulated order was grossly inequitable, usury, latches. I mean, it sounds in unconscionability or equity doctrines, which may fall within 2612C1C, which is misconduct of the parties, or perhaps even 2612C1E, which suggests that an order can be set aside if it's no longer equitable. The problem with application of those factors and why this isn't a harmless error of the court is that a one-year time bar applies to challenges to an order on the basis of 2612 C1A through E. And so any challenge at the time made by the appellee in this case would have been beyond that one-year period contemplated by the factors, or excuse me, contemplated by the A through E subsections of MCR 2612C1.
But do you acknowledge that there's a world in which we remand this for the reasons you state, and then the outcome remains the same because of unconscionability, or they adhere to the 3 steps and the outcome turns out the same?
So what I would argue with respect to that, Your Honor, so the misconduct fact is one of the factors. There was no allegation of misconduct. That would have to be a new argument from the other side. But I would concede that there has not been an evidentiary hearing on these issues yet. So there is a world in which the outcome changes potentially, but that would also have to involve the appellee changing their allegations and new facts and a new record being developed that doesn't exist yet. Now, with respect to the other factor I mentioned, which invokes no longer equitable, that's a prospective application. The rule itself refers to future applications of the order, and what we are seeking here is to enforce a past application of the order. So I would argue that under those alternative factors, with the record before the court, there's not an alternative outcome that would exist, although, with the understanding that an evidentiary hearing has not yet taken place and the record would be further developed. But based on the record before the court, there would not be a world in which the court reverses the trial court's ruling here and another factor applies to essentially reach the same ruling, which is appeal. Now, with respect to the second factor under MCR 2612C1F, that my client's substantial rights are not detrimentally affected. I mean, I think a review of the opinion and order issued by the trial court here is a tacit acknowledgement that my client's rights were detrimentally affected because the court fashioned a remedy for my client for losing out on his ability to enforce the stipulated liquidated damages clause and otherwise enforce the other terms of the stipulated order by allowing my client to move forward and present evidence as to the damages that he suffered under the agreement that the court in the same paragraphs was setting aside. And so I think it's very obvious from the record that my client's substantial rights were detrimentally affected. Now, I think on the third factor, extraordinary circumstances, there was no finding or analysis within that framework from the court. But I think what is clear is that there aren't extraordinary circumstances. This is the parties enforcing the terms of an agreement which they voluntarily enter. I think the authority provided in the briefing is clear that when parties seek to enforce the terms of their voluntary agreement, there's not extraordinary circumstances that exist. Again, we've cited to the Moore case just as an example of stipulated liquidated damages that were previously approved by this court. That was at the rate of $175 a week, whereas that voluntarily agreed to by the parties in this case was lower. And the fact that the appellee by her own actions incurred a substantial amount of damages under those terms is not extraordinary. It's exactly what was contemplated by the parties when they entered the agreement and the very purpose why a stipulated liquidated damages clause was included therein. And, we point the court to the Rose v. Rose 289 Mishap 45 case. I mean, our position is that that is exactly on par with the case here, and what the court should look to. In that case, the trial court's failure to apply the three-factor test led to the trial court's opinion being overturned and remand.
Can I go back and ask
Yes,
you
sir.
a question about, so there's a 1 year limitation, 1 year deadline for subsections A through C, is that right?
I believe A through E, Your Honor.
Well, I think it's A through C, and then the rest of it is reasonable time. Well, I'll tell you what my underlying concern or question is, and that's that, courts, whether or not the trial court in this case went about this the right way, courts don't like to be used for wrongdoing by somebody else. And I'm just wondering if this contract was either procedurally or substantively unconscionable, due to, negotiation power imbalances, due to coercion or duress, due to the liquidated damages clause being totally unreasonable. Whatever one might say in a breach of contract world. It seems odd that a trial court would be totally powerless after 1 year to do anything but enforce what they wouldn't otherwise enforce in a regular breach of contract. Now, none of this was exactly addressed by the trial court, so I'm not exactly talking about the outcome of what happens today, but there's something about your argument that seems to be suggesting that the trial court just had, that there's nothing they could do. They had to enforce this contract, even if there were problems with this contract in the making or in the substance.
So 2 points, Your Honor. First, Your Honor's correct. The 1 year strict statutory or court rule time bar does apply to C1, A, B, and C. The time limitation suggested for the other sub rules is within a reasonable period of time. Now, with respect to Your Honor's specific question, our position is not that the trial court has no option. Our position is that the trial court needs to follow the case law and apply the factors under MCR 2612 C1F. There's a three-factor test that has been developed over time with notions of balancing these competing interests of courts upholding their prior orders, and allowing for there to be sort of consistency, and allowing parties to expect that orders beyond a year will be upheld, except in circumstances in which that three-factor test is met. And so the problem, I think from one perspective here is I'm before the court arguing both that the three-factor test must apply, but also, of course, that if it is applied, I would prevail. And that's that's as my client's advocate, that's the position of course I must take. Perhaps it would be a different argument today if the court had first applied that three-factor test, and then there would be more of a record or more discussion with respect to how that three-factor test was applied and what the court's options, I suppose, would have been with respect to those overarching concerns of fairness and, not encouraging parties to, I mean, Your Honor didn't necessarily say this, but I think I'm following where you're going, which is encouraging parties to reduce contractual agreements to judgments and then
Wait 1 year
and then hiding behind their terms after a year. I think that's what MCR 2612C1F is designed to prevent. And I think that's why the three-factor test applies. I mean, the Rose case, I think you can see that the court is sort of acknowledging that there is a time and a place in which the orders will be set aside, but it should be rare. And that's why that three-factor test should be strictly enforced. And so, I would add, to emphasize this morning, the Heigl case, I think does not, it is distinguishable both from our case and from the Rose case. I mean, first, it was decided prior to the Rose case, but second, there was allegations of misconduct in that case. I mean, in that case, a spousal support provision was set aside after the record evidence suggested that the parties entered into it on where one party was making false promises of remarriage and abuse of a marital relationship. Nothing like that occurs here, and so it's distinguishable on the facts from both the circumstances and the allegations here and the Rose case. Now, I think it's also important. Our position, of course, is that MCR 2612C1F is what applies and where the analysis should lie. I mean, there was, this other argument raised by the appellee that this is, the court has broader equitable powers, or that the concept of usury should apply. I mean, we would argue that grossly inequitable is not in itself an independent ground to set aside the order, and I think that's come up through your Honor's questions. We would also argue that the concept of usury is inapplicable. Usury laws govern interest on loans or money. This is not a loan. I haven't seen authority which suggests this specifically here applies in some way. I mean, Your Honor, if you have any other questions, I'm happy to answer them. Otherwise, I'd reserve the right to rebut any responses given to questions to the opposing side.
All right, thank you very much. You do have time for.
Thank you, Your Honor.
Ms. Reisberg, why don't you come up to the microphone and put your appearance on the record, and we'll see if there's any questions for you.
Emily Reisberg, appearing on behalf of the appellee, Stacy Maria.
And I'm sorry, I announced the case with, I know the name changed, so.
Oh, that's okay. That's okay. No worries.
Well, let me just, I guess I'll ask a question to start us off. I don't see in your motion to set aside any reference to the court rule we've been discussing. Talk about unconscionability generally and some other things and some of the facts and circumstances of what went on in the negotiations, et cetera, et cetera. So I guess I'm wondering your take on, was this motion brought under that court rule? Does it have to be, or do you have independent grounds for challenging unconscionability and that sort of thing?
Yes, thank you. No, we did not reference MCR 2.612 in our motion. However, in the request for relief, we do have a clause that says that any other request or any other remedy that the court would find equitable and just. And as this court knows, the family law court is very much a court of equity. In terms of how does the unconscionability work into and potentially dovetail and work with what Judge Johnson actually ruled, I think that, I mean, if I could back up for a second, there's a lot of talk about this. There's a lot of argument from Mr. Allen about the mandatory 3-factor test that is set forth in Rose. And we do not read Rose to say that it is a mandatory 3-factor test. In fact, we read it to say what it actually says, and I quote, that furthermore, the party's divorce judgment in Heigl, this is a reference from Rose on page 7, apparently did not incorporate a non-modification clause. Consequently, in that case, the circuit court's decision to favor fairness when it construed MCR 2.612 remained unconstrained by competing considerations of finality and freedom of contract. So, I do want to address that issue to say that Rose doesn't necessarily impose the same strict standards upon the present issue, because in the present case with these two parties, there is no non-modifiable clause in their agreement in this order. It doesn't say that it's non-modifiable. That was not specifically bargained for. The finality that the court talks about specifically bargaining for is not present in this agreement. And so the court in Rose explicitly states that they are not constrained by these stricter standards if there is no non-modifiable clause. And because that's what we have here, we then turn to saying, okay, well, if they're not restricted by those 3-factor standards, we're just looking at MCR 6.12. I do think that the court has the authority in a court of equity, especially with the request for relief of any other equitable remedy under law, to take it upon its own motion. There's nothing in 2.612 that says it has to be specifically pled, right? There are specific issues, defenses, causes of actions under the law that we do have to specifically plead or they are waived. There is nothing that I'm aware of that says MCR 2.612 is one of those remedies. So the court was well within its authority to go forward and rule on the basis of MCR 2.612. And when it did that, as this court has pointed out with Mr. Allen, it wasn't constrained by the 1-year provision. That did not apply. It would be a reasonable time. And as we've briefed in our response, the motion by Ms. Morea was brought to set aside and to get relief from this judgment only after a motion to show cause was filed by Mr. Robach. And we filed several months later, which I would say is a reasonable time. It wasn't until years after this alleged $83 expense was missed by Ms. Morea, allegedly, that Mr. Robach came forward, filed this motion and said, hey, I've been sitting on this. And he didn't say that. That is our interpretation. And now it's $40,000. So I think that the court was completely unrestrained by Rose and had the ability to fashion whatever equitable remedy it needed to. I do think that if this were analyzed against the principles of contract law, as opposed to 2.612, that there would be a finding of unconscionability. I also think that the court did in, let's say, function, maybe not in form, went through this 3-part test that Mr. Allen is talking about almost automatically in discussing, what it felt, what it saw going on here. The court, nobody is disputing that the first prong of this analysis, whether A through E applies, that's not disputed. So we're essentially looking at the second and third prongs. And the first one is whether Mr. Robach's substantial rights were detrimentally impacted. Well, Judge Johnson found that this was unenforceable, that it was grossly inappropriate, that it was shocking, that there was an issue of latches. We in our brief and Judge Johnson likened it to a violation of usury laws. We're talking about 110,000% penalty on something. And the judge goes through and mentions that, yes, absolutely, this was shocking. I'm not going to enforce an unenforceable clause because this is grossly unequitable. So she does, however, preserve his substantial rights in the sense that he still has a hearing. He doesn't have a right to have an unenforceable clause enforced. He has no substantial right to that, to enforce an unreasonable liquidated damages penalty. The law doesn't provide for that. He has a right to enforce the enforceable parts of the contract, and that is still out there. There is still an evidentiary hearing that will be scheduled to determine whether or not Ms. Morea paid the $83 and if there are any other unpaid expenses. So his substantial rights, the ones that he actually has, are very much still intact. And then if you look at the third prong, again, perhaps not in form, but in function, Judge Johnson did also address that. There are extraordinary circumstances here. This is a case where we have an $83 payment that somehow became $40,000 over the course of several years. And I would also argue that there were allegations of misconduct as well, going back to the unconscionability piece. In our briefing, we talk about how there was a degree of duress. The kids, during the negotiation process, Ms. Maria was scared that Mr. Robach was going to tell the children all the dirty details of the divorce. This was something he threatened. He said, I won't provide health insurance for our adult children unless you sign this. She didn't have a means to provide health insurance to the adult children. He's a practicing attorney. He's been an attorney for many, many years. I mean, these were all outlined in our pleadings. So ultimately, at the end of the day, I think if this case were remanded, we come back, and if the court wants to look at the unconscionability argument, they certainly can. And I think we end up in the same result. But ultimately, I do not think that the court has to follow a specific three-pronged test as outlined in Rose, because we do not have a modifiable clause in this provision. We do not have a provision that says you cannot modify. So the gate was open for 2.612C, and the judge used that to rectify this wrong that has been occurred.
612E, I believe, or F.
612 F, correct. Yep.
All right.
Which is extremely broad. And I would argue that this circumstance is precisely the circumstance that that rule allows for, that the reason it exists.
Thank you. Any further questions?
I don't have any-
Thank you very much for that. And Mr. Allen, you have rebuttal?
Yes, Your Honor. And so a few points. I think first, this allegation of duress was not an argument that was made as a basis for setting aside, and the misconduct prong of 2612C1 was not invoked previously because, as counsel acknowledged, MCR 2612 was not referenced at all in the underlying motion. So those were new issues raised for the first time today. Now, with respect to extraordinary circumstances, I mean, the Rose case specifically stands for the proposition that a lopsided or harsh outcome is not extraordinary. Extraordinary circumstances generally arise when the judgment was obtained by the improper conduct of a party. That's what the Rose case says. And so the fact that a negotiated agreement with stipulated damages later results in a harsh outcome for one party or the other doesn't create extraordinary circumstances. It creates circumstances that were contemplated by the parties at the time they were agreed to. I mean, if a court were to say that a harsh outcome of this type where liquidated damages provisions are enforced is harsh and can be a basis for setting a contractual agreement or an order aside, how can parties enter stipulated orders and rely on their provisions, particularly their stipulated liquidated damages provisions, being enforced in the future? It would create unnecessary doubt that's not supported by prior holdings or by the underlying record in this case. Now,
but there are limits on liquidated damage, right? You can't just come up with whatever you want.
Absolutely.
Right?
And I think those.
So the question is, what is the procedural mechanism when there's a liquidated damages clause and one party wants to enforce it and the other party is like, wait a minute, this is not within the realm of what's legal to have in an agreement?
Well,
is it a motion for relief from judgment under 2.612? Is it just a defense to, hey, you know, there's been a motion to enforce this judgment and my defense is, you know, this clause isn't enforceable? Because I'm just, you know, it just doesn't make sense to me that it's just like, well, you're stuck with it and that's the end of it.
I think, I mean, the first part of your defense has to include an analysis of the circumstances under which the terms were originally agreed to. I mean, that's the principle from contract law, that the conscionability or unconscionability of a contract provision is determined at the time the agreement was entered. And so in this case, what we have is the party seeking relief from the liquidated damages is the party who in fact suggested that amount. And so, I mean, in other cases in the future, and I understand Your Honor's concern, I think that analysis is key, and every case has different circumstances under which different contractual terms are proposed and ultimately agreed to. But I also think, I mean, it is a cautionary tale with respect to parties voluntarily entering into an agreement and what the terms of those stipulated liquidated damages are. And now with respect to the other aspects of your
Can I
honor's.
ask one related?
Yes.
Suppose, so we've talked about the fact that the motion, but there was no reference to 2.612C by plaintiff, right? That was something that the trial court used?
Yes, your honor.
That was something that you advocated to the trial court, is how the trial court had to look at this.
I did argue that
The
at the
framework
hearing.
through which to.
Yes,
Right.
because
So suppose instead of, suppose once your client said, hey, I want an order to show cause, I want to enforce this contract / order, the stipulated order. The other side had said, look, we're not advocating for relief from the judgment. We just don't think this contract is enforceable. Is that a separate question, or does everything have to get funneled into 2.612C and therefore funneled into this 3-part test? Do you understand what I'm asking?
I'm following your honor. I think, perhaps there are circumstances where they don't have, where the dispute doesn't have to be funneled within that framework. What we had here is, the opposing party filed a motion to set aside the order, now without invoking that rule, but that was the relief they were seeking. And so it wasn't even a motion to modify the terms of the stipulated order or a motion for relief, as your honor suggested. And so that's not what we have here. And that's not what's been argued by either the other side in this matter, and it's not what was interpreted or analyzed by the underlying court. And so, to be perfectly honest, I would have to just acknowledge that there could be circumstances where a separate motion would be the better route to go to challenge, a specific provision or even the results of a provision or a calculation under a provision. And I think, your honor called it a motion for relief. I think something like that may be more appropriate, and it wouldn't necessarily invoke setting aside a stipulated order in its entirety, which is that was the relief requested, and that was ultimately what was ordered by the court under.
How is it substantively different? Saying, I want relief from this order because it's unconscionable and unenforceable, or saying, I want you to set it aside for the same reasons. Isn't it the same, one of the same?
Well, perhaps it's not. I think in response to the panel's questions, perhaps there's a time and a place for a modification or targeted relief. But I think, our first position, but before the court is that, and the argument we've made, and the argument I made to the trial court, after reviewing the motion that was actually filed by the opposing party in this case, is that MCR 2612 is the framework and has to apply. And so the circumstances in this case, that is the mandatory framework. And if you're seeking relief that has the effect of setting aside the judgment, then yes, we would argue that 26162 is the mandatory rule. The cases interpreting that are mandatory, and the cases applying the 3-factor test under 2612 C1F must apply. That's our position in our argument. I think to the prior question, I think, I don't think that in this case, ruling that the court was required to follow MCR 2612, and as a result, the only prong, and the prong that the court did analyze was MCR 2612 C1F, finding that applies, that's the proper prong, that the 3-factor test must apply, and overturning the trial court as a result of not following the proper 3-factor test and not making the required findings, doesn't necessarily prohibit some other special circumstance, which doesn't exist here in this case, in which there may be another basis to seek relief, as your honor was suggesting. I think there, with respect to what is before the court here and what relief was sought and then granted by the trial court, I think the ruling is more targeted than having the effect of cutting off any ability to challenge outside of the framework. But I would add, and as I think we discussed before council had the opportunity to answer the court's questions, that 2612C1F and the three-factor jurisprudence has been developed with over time with a judicial understanding of the need to balance interests of having a means of providing relief from judgments which are unfair after an analysis of that three-factor test, and finality and reliability of the enforceability of judgments which parties which enter into them must be able to rely on. Okay, the other point I wanted to refer back to is this non-modification clause issue. I think counsel suggested that distinguishes the Rose case. We believe otherwise for three reasons. First, the order at issue in this case is functionally non-modifiable midterm. It can only be terminated prospectively via the October 1st opt-out provision, not retroactively adjusted. And that's eventually what the appellee in this case did. The agreement was terminated. And so with respect to concerns about parties being trapped in a contract with unconscionable terms, I mean, this stipulated order had a means contemplated by the parties for termination at the outset, and that's since been exercised. And we're not challenged. There's been no challenge to that. The agreement going forward is over based on exercise of that opt-out. The second aspect, or excuse me, the third, or excuse me, the second reason that we would distinguish the existence of the non-modification clause is because the spousal support context in the Rose-Heigl cases is based on notions of fairness regime that an opt-out clause overrides. I mean, that notions of fairness regimes exists in those other types of cases, but it doesn't exist with respect to a healthcare cost order that was never subject to ongoing judicial fairness review in the first place. It was simply a negotiated term of the stipulated order. And so for that reason, the absence of a non-modification clause is a distinction without a difference for the purpose of the subsection F analysis. Your Honor, if you have any further questions, I'm happy to answer them. Otherwise, we'll rely on the relief request in the briefing.
Yep. Questions?
I don't have any.
No further questions. Thank you very much.
Thank you, Your Honor.
both. Thank you for being here for questions, and that case is submitted. That brings us to the final item on our August case call, number 23, case number 378281, in re Scheiber Burns Miners, and that case is submitted for the briefs. And that concludes our case call.